We've had a lot of questions over the last 48 hours asking us to explain exactly what happened in the case against the referendum to petition election that was asked for and sought for from the people. And so I'm going to try my best to use this video to help you understand exactly what happened through that process. I want to say from the outset of this video that we are in no way trying to bring blame or anything to any party, but we have a lot of people who were committed to this process and want to understand what happened, and so I am going to try my best to explain that for you as I can. We're going to start over here at the Industrial Revenue Bond Guarantee Law, Act 173 of 1967. And I'm going to kind of short change through this. I'm going to tell you that what we were talking about here was an Act 9 bond. And you can see that this means revenue bonds issued in accordance with the provisions of the Municipalities and Counties Industrial Development Revenue Bond Law, or ACA, annotated 14-164-201. And that is, ironically, that is the case that we are actually fighting in trial against the judge. But it also was tied to this referendum to petition and election piece. And so I kind of want to show you what this is. The very last sentence of this says that a vote of the local governing body is required to issue these bonds. Now, I'll take you over to this same subchapter in Section H, and it describes to you by definition what a local governing body is. The local governing body means the quorum court of a county or the council board of directors or other elected governing body of a municipality. So we can see very clearly there that this is describing the quorum court. Now again, this ironically goes to our case because we're going to show you where some of this got off track. Going into the referendum to petition, you will see here that when you enter into one of these bonds, there is a sequence of events that must happen. And at the very beginning, you'll see a memorandum of intent by the governing body, the city or the county. And this kind of sets into motion what is going to happen. That's a memorandum of intent of, hey, this is what we intend to do. And that is normally put forward by the governing body. Now, that was not done in our case. What was done in our case was something more along the lines of what we're going to show you later, which is an order by the judge himself. There was no memorandum of intent put forward by the quorum court here, as we know that subsection H has defined that that is the governing body. Step number 2 is a notice of the hearing. 10 days prior to the hearing, a notice must be given and set forth in the paper. We know that that happened. A public hearing was held on April the 1st, and then we were allowed prior to the adoption of the ordinance, which again, I want to say to you, the ordinance is an article that is put forth by the quorum court. So again, we're missing a step here. We don't have an ordinance at that time. But the next step is a referendum of 30 days, referendum to give the citizens a chance. You'll read there, it gives the citizens a chance for a petition, if desired, to basically file a referendum against this municipal issue. Gives us 30 days to do that. Final step is an execution of the documents. This is the procedure that takes place by the county court or the county judge when a bond is actually signed and executed. Now, I'm going to stop right here and just kind of explain just a few things. So going into this, we did not have an ordinance and we did not have the quorum court's approval for such a measure. So we did have an issue right here. But on July the 16th, an order was signed by Judge Larry Cowling in the amount of $400 million for this project for the solar development. At which time we filed a referendum to petition. We filed really 3 things. We filed an appeal to the motion and asked to be took to trial. We filed for a temporary injunction, and we filed a referendum to petition. So for the sake of this particular video, we're going to kind of focus on the referendum petition. And so what you'll know is from July the 16th, we had 30 days to turn in enough verified signatures to file a referendum to this petition. So on August the 13th, 2025 at 2:22 p.m., I hand-delivered 838 petition signatures, and these were signed for by Miss Heather Parsons. As you can see, well within our 30-day range. We had plenty of signatures. We needed 579 to be eligible, and we turned in the 838. Later, there were a few more signatures that day turned in by Hannah Crow. I do not have documentation on those particular signatures. What you'll see here next is the verification or authentication of these signatures, and this was done through the county clerk's PowerPoint program. And this is a program that allows them to kind of input the address, the name, and it allows them to validate that we have these particular folks are eligible to do this. And you'll see here up in the upper right-hand corner, page 1, it shows that 10 out of 10 of these folks were valid. That was signed for by Heather Parson, and the date that those signatures were verified, these particular 10 were verified on August the 18th of 2025. On the following day, you'll see that on page 93 of this batch of signatures, 10 out of the 11 verified off of this particular page, so somebody was rejected here. This again was done by Heather Parson. It was done on the following day, 8/19 of 25. This was the final day of signature verification, and this was wrapped up at about lunchtime. And you're going to see here that, let me go back. So out of this, you'll see a little later that we had plenty of signatures at that time to host, to meet the requirements of the referendum to petition. So on the 21st, they took the signatures and all of the information that was given to them, and they went into a Little River County Board of Election Commissioners meeting. And in that meeting, they approved this election, and they approved our signatures, and everything was set forth for an election. As customary, the next step, they went to their Facebook page in the Little River County Elections Commissions. They notified the public that there would be a special election. The special election would be held on November the 18th, 2025, regarding the order of the County Court of Little River County in the matter of the issuance of industrial development revenue bonds by Little River County, Arkansas, that were dated July 16, 2025. This election was prompted by a referendum petition submitted by registered voters, and as a result, the matter will now be referred to the people for a vote. This is the official date that you should keep in your mind, August 21st. This is the date that this was made official and made public. Now, because it was made official on Thursday and it missed that week's paper, on the very next week, on the 28th of August, the Little River Journal picks it up and they make it official by publicizing it in the paper that yes, indeed, we will have a special election on November the 18th. I want you to make special notice to the fact that the dates are already established all the way back in August. Your early voting, your polling locations, all of that is established back in August. And so we know very clearly now as a people that yes, we'll have an election, and yes, this was certified on the 21st day of August. That becomes important because the case that was brought against your election reads it was based off of Arkansas Code Annotated 1414-915F, which states this. Furthermore, this matter is brought pursuant to Arkansas Code Annotated 1414-915 Section F, which states that any taxpayer, Mr. David Madden, aggrieved by the action of the clerk in certifying the sufficiency or insufficiency of any initiative or referendum petition may, within 15 calendar days, but not thereafter. And that's very important for you to remember. Not after 15 calendar days may such a person file a petition in the circuit court for a review of the findings. Now, this is ironically exactly what happened, is that we had a review put forward to the circuit court to decide the sufficiency or insufficiency of our election. And you'll see here that this was started on the 21st of August, and the 15 calendar days end on the 5th of September. You're going to see a couple other dates, the 12th and the 18th marked there. I'll get back to those dates in a minute. But for time's sake on this piece, just see that the end of this 15-day period was on September the 5th. So then something happens over here on September the 18th, and there is a lawsuit filed by Mr. David Madden against the Election Commission. And you might ask yourself, well, how is that possible if this ends on September the 5th. Couldn't be possible. But it is possible because on September the 18th, when the lawsuit was filed, Mr. Madden was only 6 days into the actual certification of our election. Now, that may throw you for a loop, but I want to kind of show you how this happens. On September the 12th, a special meeting was called, and this special meeting was called by the attorney of the opposing party. And so they reached out to the county clerk. They asked for a special meeting that would be held only with their lawyer, the county judge of this county, Larry Cowling, the county clerk, Ms. Deanne Sibley, Mr. David Madden, a private citizen, Mr. Bill Aiken, a private citizen, and the 3 members of the election commission. Nobody else was notified of this meeting. There was no public notice made in accordance with the Arkansas Freedom of Information Act. This was a special meeting called with no notice to anybody except those involved in that meeting. Now, in that meeting, what we came up with is, you're going to see here, now we have a certification date on our signatures, the 872 signatures put forward. You're going to see that these are certified now. Now, you might be saying, well, wait a minute, Tracy, I thought these were certified back over in August. Well, and that would be what we all thought as well. And that's why the election was called into order, because those signatures were found to be certified. But here you're going to see that these are certified on a new date, which is September the 12th, 2025. And with that date in mind, now you can understand why a September 18th lawsuit fits very nicely into those 15 days. Now, in addition to that, what you may read here on subsection 12 is you may read that on September the 12th, 2025, the Little River Election Commission met and unanimously called for a special election to be held on November the 18th, 2005, we're assuming that means 2025, based upon the citizen petition and county clerk's certification. Now, this is kind of unique because this was already determined back on August the 21st before it was put out in the paper that we would be having an election on November the 18th, 2025. Now, this takes us back into the lawsuit again, where again I want to remind you that 15 days allowed our opponent, Mr. Madden, to come forward and contest the sufficiency or insufficiency of our referendum petition. And the reason that he was able to test that and put that into court, and the court brought that down, is because of the changing of the dates. And you'll see here that the dates on September 12th, a new date was set, a new filing, this is when this thing was certified, this is when we're going out, and that allowed Mr. Madden within 6 calendar days to file a lawsuit against this referendum to petition election on September 18th. Now, to all of this, I just want to say that we don't want to try to, discredit anybody. We're not here to bash anybody, but these are the facts in our particular case. These things actually happened. These things were brought up in our trial, and these are the answers to these questions. And so I want you to understand that this is what happened. You make your own determination from here as to what you feel has happened here. There were what the circuit court judge ruled, and I want you to, this is very important. What the circuit court judge ruled is that because there was no legislative action taken and there was no quorum court involved in this order, that she would not allow us a referendum to petition election because the legislative process of that bond was skipped. It was not taken. There was no legislative action taken on that bond. We absolutely agree with the judge in the sense that there was no legislative action taken on that bond, and so that is what we are contesting in a trial against Judge Cowling. But you have to separate that issue and understand that that is a separate issue to whether or not this election would have proceeded anyway if the 15 days had expired, and the answer to that is yes. If the date had not been changed on our certifications, your election would not have been allowed to be contested in court, and that is what's important for you to remember. And so I want to make this video. I hope it's helpful to you, And again, this is not meant for you to do anything except know what we know, see what we see, and hopefully it will be a help to you as we move forward. And so with that, I want to say thank you and God bless.